Queen against Maxwell.
Yes.
May it please your Lordship, good morning. I appear for the appellant Paul Maxwell together with my learned friend Mr. Sherratt. The respondent is represented by my learned friends Mr. Perry and Mr. Mabley. My Lord, the certified point in this appeal is as follows. May the Court of Appeal order a retrial having quashed a conviction on the grounds of serious executive or prosecutorial misconduct, and if so, in what circumstances? The short answers of the appellant and respondent appear as follows. At the beginning of our case, which is of course in Core Volume 1, Tab 3, at the first page, A2, our proposed answers are as follows. There is no power to do so where, in light of the alleged offence and of the misconduct, the retrial would cause material damage to the integrity of the criminal justice system as a whole, or where, but for concealment and deception of the courts by the state, a stay on the ground of abuse of process would have been granted at an earlier stage of proceedings. B, if there is such a power, there is a strong presumption against its exercise in a case where the retrial, in light of the alleged crime and the misconduct, would cause material damage to the integrity of the criminal justice system as a whole. Only in the most exceptional circumstances could a retrial be justified. It's not possible or desirable to provide a complete definition of all the circumstances in which that may happen. My Lord, the respondent's answer to the certified question appears at the end of their case, the last page, paragraph 88. The Court of Appeal may order a retrial having quashed a conviction on the grounds of serious executive or prosecutorial misconduct. The circumstances in which the Court of Appeal may order a retrial include A, where the effect of the misconduct in question will not manifest itself or be carried over into the proceedings, or B, where the public interest lies in having a determination on the merits of the charge, notwithstanding that the misconduct may manifest itself or be carried over into the trial. And A finds its source in the Canadian case of Regan, which my learned friend urges upon you.
The reality is, isn't it, that you're both answering the first part of the question, yes. Because you say, effectively, yes, unless one of the two things applies. And they say, yes, provided, or in circumstances including the following. Therefore, I think your first and your second answers, A and B, are a little contradictory, because in your second one you say, if the answer is yes, then it's not possible to provide a complete definition. But in the first one, effectively, you say the answer is yes, but here's a complete definition.
Yeah. Well, Lord, with respect, I hope they're not contradictory, because B is in the alternative and addresses the alternative scenario where we're wrong and there is a power, and it's addressing the exercise of discretion.
But I don't think you've understood my point. The point is your answer to yes is effectively yes, there is a power, unless it would cause material damage to the integrity of the criminal system, or unless a stay would have been granted at an earlier stage. So you are saying yes, but you're setting out two defined circumstances, where in your second answer you are saying yes, but you'll say it's not possible to provide a complete definition.
Well, my Lord, that is because of the dicta in Hunter and the Chief Constable, and also Shazad and Latif, where Lord Diplock and in the second case Lord Steyn indicate that it's impossible to set out rigid rules here, rigid factual criteria. We seek to impose, certainly here, a limit upon the power to order a retrial, which is consistent with the criteria for the grant of a stay. And we seek to submit that the fact that this is a retrial, the statutory discretion under Section 7 to order a retrial doesn't affect the the circumstances in which the state should be granted or a retrial refused. Those criteria merge, and the statutory test under Section 7, where it is required in the interests of justice, is exactly the same and doesn't add or detract from the criteria for the grant or refusal of a stay. My learned friend suggests that the fact that this is an application for a retrial changes the approach of the court, and that the criteria for the grant of a stay would impose a fetter on the Court of Appeal's discretion under Section 7 of the 1968 Act. We submit is not a fetter at all, because they walk hand in hand. The interests of justice in granting a retrial are going to be entirely the same as the interests of justice in granting or refusing a stay for state misconduct. But, my Lord,
I'm sorry, I'm a bit lost on the stay. I mean, you have to have the scenario. What's the scenario for the stay? What's the factual state of play when you're asking yes or no, would there have been a stay? I mean, of course, if you're asking yes or no, would there have been a stay, if the only evidence in the case was this Mr. Chapman, and it had suddenly been discovered, etc., etc., etc. But if you then add in all the admissions, which it is, of course, the basis for the Crown now saying that there should be a retrial, I'm not at all sure that there would then be a stay. I mean, you know,
yes.
so I'm not sure it really adds anything to ask whether there would be a stay or not.
Well, my Lord, if we could have persuaded the Court of Appeal that on all the facts before the Court of Appeal, that would have justified the Court of Appeal granting a stay notwithstanding the evidential development, then obviously they would have refused a retrial. That's why there is no distinction between those two approaches. Now, my Lord Brown has just put to me what is surely a critical question to this appeal. May I try to put it neutrally? Does this strong evidential development, which it is, a clear prima facie case, recreate the moral foundation of the state for prosecuting Mr. Maxwell, which we submit had been destroyed by this degree of state misconduct? In other words, this is the core of the respondent's case, that this evidential development removes the moral taint that has been caused by this state misconduct. That's the respondent's case. Our case is that no such evidential development can do so for the following reason: that the rationale for the grant of a stay here has nothing to do with the state of the evidence. As in Mullen, where he had been properly convicted and where he had no complaint about his conviction, a stay was granted, notwithstanding the overwhelming and accepted state of the evidence.
Mullen was really a Bennett case.
Yes, exactly. So the whole rationale behind this branch of the jurisdiction of the court to grant a stay has nothing to do with the state of the evidence. Hence, our submission is that a change or development in the state of the evidence cannot restore the moral standing of the state to prosecute, cannot change the situation, as the respondents claim. And we'll need, of course, to look at, and I will need to persuade my Lord clearly, that it is the moral standing of the state which is at the core of this jurisdiction. And it has nothing to do with the state of the evidence. One can't have a better case than Mullen, where it was conceded, as we will see, that he'd properly been convicted. No question of a retrial, though. And the rationale wasn't anything to do with the evidence. It was moral standing.
But on the basis he should never have been in the jurisdiction to be tried.
Oh, absolutely, and that brings us to the but-for argument. That was the species of state misconduct in that case, which created the the immoral foundation for the state's right to prosecute. But that is plainly not an exclusive test, nor is any but-for situation we submit on careful analysis. Now, my Lord, I wanted to say at the outset, if I may, because my lords have taken me to some of the core questions, and we'll reach them very quickly. I'm most certainly not going to be dwelling upon the very many paper cross-references to the details of the misconduct. It's all there on paper. But, my Lord, I did want to say at the outset that perhaps the acuity of the conflict here is very clear. We have no hesitation in acknowledging the strength of the public interest in there being a trial on the merits for this offence. This was a particularly callous murder of a defenceless elderly man at his home in the course of a planned robbery. And the evidential development relied upon by the Crown provides a clear prima facie case of my client's guilt. I'll make submissions later about whether it's compelling or not. That's a technical question, but this is a clear prima facie case. So there is
a prima facie case of murder.
Oh, absolutely. Yes.
Not just manslaughter.
No. On the other hand, and this is the acuity of the conflict, this state misconduct is about as bad as it gets. It is truly on a shocking scale and involves a pervasive and successful conspiracy to pervert the course of justice. And as we understand my learned friend implicitly from his case, he does not take issue with any of our analysis of quite how bad this misconduct is or of its implications. And its effects have been profound and long-lasting. Of course, the misconduct included perjury before the court of trial and the court of appeal. The courts and the defence have been deceived over 13 years, and the appellant has, whatever the state of the evidence now, has been incarcerated by reason of an unsafe conviction over the last 13 years.
Where was he arrested?
He was arrested in April 2007, within a day or two of the end of the main witness statements being taken from Chapman. They started on the 10th of April, 1997.
You said 2007.
I meant 1997. I'm very sorry. I suspect I might do that again. I'm sorry. April 1997, within 2 days of the end of the process of taking Chapman's witness statements. And he's been in custody ever since.
Would it be right or wrong to say that while everything that happened in relation to Chapman was completely disgraceful, there isn't actually anything to say that the evidence he gave was itself inaccurate?
Well, my Lord, we point up, it's a detail, we point up that, for instance, his account of what Mr. Maxwell told him in a confessing phone call about the proceeds of the first robbery is inconsistent with the evidence of the victim. But that is a mere detail, may
Yes.
I say. I'm not elevating that to a point of great importance at all.
I mean, the admissions which you very fairly referred to would tend to be consistent, or would be consistent, with what Chapman said was said to him.
Indeed, and we submit that that may be rather telling, where, for instance, they're more consistent with Chapman's evidence at trial than they are with the objective reality. Because, of course, Mr. Maxwell had possession of all the papers over many years and had been advised by his solicitor, you've got to make a convincing confession. And he makes a convincing confession. It's a convincing confession. And a series of them. Absolutely.
But my Lord's writing, I mean, however disgraceful, and heaven knows there's ample to show it was, the behaviour of the police, in effect, putting Chapman beyond the scope of effective character cross-examination and all the rest of it, the actual Chapman's evidence implicating your client and the other man in these offences, I mean, is not seriously put in doubt in anything you're able to show, is it?
No, my lord. And that's plainly not the thrust of our case at all.
No, quite.
And of course,
you say, however demonstrably guilty, it would be wrong to have a second shot at establishing it.
that is one way of putting it. We do submit we're not demonstrably guilty beyond reasonable doubt. We concede that there is a clear prima facie case. And we dispute whether it is compelling within Section 78 of the 2003 Act, in the analogy that the Court of Appeal drew with that power. But my lord, the point, my lord will obviously see this immediately, it doesn't get us very far to say that we can't, as it were, tackle and demolish Chapman's evidence now, because of course that's all being put to one side. This is part of the background. I suppose one can assess the reliability of these confessions by my client by comparing them with Chapman's original evidence. I accept that, but of course that's not what's going to happen at any retrial, because all that evidence is purged away and no reliance is going to be placed upon it.
I mean, I'm sorry, I'm just thinking, I mean, I remember cases in the old days when, you know, you didn't videotape confessions and everything, where pretty routinely it was established that the police had, forged confessions, or they got a signed confession statement that added stuff in, all that sort of stuff. But convictions nonetheless stood on the basis that there was ample other evidence.
Yes, my lord.
But why on your case would they be doing that? Why wouldn't they be saying, look here, this is terrible. They've been forging confession statements. You can't just say, well, we'll tear those up and rely on the rest of the evidence.
My lord, there is a contrast of principle between those cases where convictions are quashed or even maintained on other evidence, where there is a strong suspicion that police officers had fabricated verbals, a very common suspicion, decades ago. My lord, the contrast is that in those cases there wasn't proven and established perjury and fabrication. The convictions would be quashed, or the court would approach considering quashing the conviction on the basis that these confessions were unreliable, not proven to be perjury by the relevant police officers.
I think sometimes they were proven. I can't remember the names of all these people, but there was a chap who used to, he had some new way of seeing whether what was written before something else and the rest of it.
Yes.
Do you remember those? The West Midlands police didn't come out of it terribly well, I recollect.
The ESDA test. The West Midlands police were in fact, what they did is they spirited away the original documents from the court archives before they could be tested in the most notorious episode. But my lord is positing a case which is not infrequent, where a conviction has been obtained on a range of different evidential sources, and one of them becomes potentially discredited. The Court of Appeal has to consider what to do about it. If there is other evidence, the court may well, in those cases, uphold the conviction. That is, and certainly no question of quashing the conviction on grounds equivalent to a stay. That is because the court didn't have the material before it to satisfy itself that evidence had indeed been fabricated. There's a difference between the court seeing evidence as too unreliable and actually an investigation being tainted by perjury, and that's what happened in most of those cases. Now, my lord, where there is other evidence untainted, the court will, untainted by that unreliability, the court frequently upheld the conviction. But where it was the exclusive evidence, the court would quash the conviction.
Of course.
Right. Now, we're in a very, very, very different scenario here, because the enormously detailed contents of the CCRC report and the police report behind it, which is even more voluminous, establish beyond peradventure, so that it is unchallenged by any party and accepted lock, stock and barrel by the Court of Appeal, that effectively the whole of this investigation, which depended upon Chapman's evidence, was a conspiracy to pervert the course of justice, and one so detailed and so shocking, and certainly perjury by police officers before the court in order to buttress Chapman's evidence, perjury before the Court of Appeal when the court had adjourned specifically to consider questions of incentives and rewards for Chapman. It's a completely different order of misconduct with completely different order of consequences. So that this is to be distinguished from those many cases, even those called dignified with the name miscarriages of justice. Miscarriage of justice was where a long-standing conviction, normally after a first unsuccessful appeal, has been overturned because the evidence is shown to be unreliable. That doesn't take anyone into stay for abuse of process territory.
So I wonder, could we just go back to section 7? I think it's in volume 6, just so I clear up exactly the shape, because I think you touched on it at the beginning, just so I understand in time. It's tab 56.
Sorry?
Volume 6, tab 56.
Tab 56, thank you.
Yes. The power to order a retrial,
Yes.
which is what we're talking about,
Yes.
as I understand. Now, the answer to the question you say is no, there's no power in this case to order a retrial, isn't that right?
Where the retrial would threaten the integrity of the criminal justice system.
Yeah, well, just so
That's just like saying yes unless.
Of course.
I know, but I mean it's...
My Lord, if we're saying no, we'd be defying Parliament. There is obviously a power to order a retrial, yes. But our submissions have to be confined, of course, to the circumstances of this case. In this case, after this prosecutorial misconduct, the power does not exist where, on assessment of that misconduct, the retrial would threaten the integrity of the criminal justice system.
I sort of do understand it. I just want to be clear what it is that you're saying, therefore, and you say, therefore, what your argument must be, is, as I understand it, or just to see if it is right, that it could never appear to the court in these circumstances that the interests of justice require that the defendant be retried. Is that right?
Where the retrial would threaten the integrity of the criminal justice system. In other words, where the criteria for a stay would arise.
Yes, but the test is, it appears to the court that the interests of justice so require. Now, if your answer to the question is that it can't be, there is no power to order a retrial, then it can only be, unless I misunderstand, is that it could never appear in these circumstances to the court that the interests of justice require there be one.
That's right.
Is it just a verbal distinction between there is no power and the power should not be exercised in such circumstances?
Yes. I mean, there is a power, but it cannot be exercised in these circumstances. I'm sorry, I've probably created this slight conundrum, and I suspect I really don't want to be starting us going around in circles. I've got to get through a lot of material. But if there's lack of clarity, I do apologise.
Don't apologise.
There is a statutory power, but in these circumstances, it cannot be exercised.
Well, that's Lord Mance's original point, and you now accept it.
Well, yes. I'm sorry if I've caused confusion, and I don't think there's any there's any distinction. There's certainly no distinction, we submit, between the interests of justice in this Section 7 statutory test and answering the question about whether a stay would be justified on these facts. It must produce the same answer.
Yes, in other words, it's really tantamount to staying.
Yes, it is. It is. Now,
if the admissions had come out in a completely different way, you might find it difficult to suggest that the original obviousness of a stay was the end of the matter, mind you. I mean, supposing the miscarriage of justice having come to light and the defendant was advised by his lawyers that he had a cast-down case for having the original conviction set aside. But he then volunteered an admission completely outside the context of the fact he'd been convicted. Would you say that he couldn't then be tried, or supposing he even did it publicly? He said, they can't get me now.
Yes. Well, my lord, I have tried to, I think I may hopefully successfully have come up with a very stark example of where the moral foundation of the state for prosecuting this case could be restored by certain conduct of the appellant. And it really develops my lord's thinking. Let us say that the conviction is quashed to court by reason of the exposure of all this misconduct. And under the assumed immunity of that quashing, without any stay or anything, the successful appellant wrote a book for profit, boasting about precisely how he had committed the offence. Now, the prosecution are entitled, under the Criminal Justice Act 2003, sections 75 to 78, to go back to ask the court to order a retrial in those circumstances. And the battle would be between, we submit, the remaining taint on the state by reason of the proven misconduct, as against the not just distasteful and unattractive, but dreadful conduct of the appellant, cocking a snook at the criminal justice system and profiting from it. Now, there may well then be a real forensic argument about whether that overrides the moral taint over the state standing to prosecute. Because the appellant, the former appellant's misconduct, is cocking a snook at the criminal justice system.
And in that situation, it becomes in the interest of justice to order.
It may do. I mean, it'll depend on the facts. I mean, depending on how bad the mis. Yes.
But that would be the test. It would still be the same test.
Exactly.
But in that situation, you say the cocking the snook and all that.
That's right.
Then shifts the balance, and
That's
it becomes in the interest. Yes.
Indeed. Now that is an
You're now looking at that would be a Section 75 application.
Yes.
And is that also
79? Section 79.
That's right.
Or 79? I mean, I'm just
Directing the court's attention to the interests of justice.
Yeah.
Absolutely.
sorry. Where is? I'm just looking at 75 is tab 58. Huh?
Yes, 79.1.
Where's 79? It's in the same tab. Is it? Yeah. I see. Interest of justice come back in there.
And
Yeah.
so, my lord, I hope sees the distinction, and it is one of principle, because in such a situation, the rationale for the grant of a stay is truly counterbalanced by something of the same kind, whereas the mere fact of the emergence of evidence doesn't, because the rationale for the grant of a stay originally was not defect in the evidence. This redresses the balance of moral standing. And the answer then...
enter a marker that I just don't see why we're complicating it by concepts of stay when, on the face of it, that's just introduces a needless complication.
Well, my lord, the first answer to that is one of our first criticisms of the Court of Appeal's judgment, and if I may, I'll take my lord through the Court of Appeal judgment and the structure of it. But my lord, the first answer to that is that Mr. Maxwell has only been deprived of a terminatory remedy, the grant of a stay at trial, by the state misconduct itself. He was only similarly deprived of that remedy during the 1999 appeal by the continuing state misconduct, including perjury before the Court of Appeal, of which you have the transcript. Now, it is particularly odious that one should ignore that, therefore, when it is a product of the very misconduct that he didn't get that remedy then. And even more odious when he has continued to suffer the consequences of being deprived of that remedy over the last 11, 12 years, depending whether it's from trial or from the first appeal. And so it would be to reward the misconduct which concealed the grounds for a stay long ago, to ignore his, if it is an entitlement, that's for me to make good, but if he was entitled to that remedy at trial and on appeal, that is not something that is a distraction or should be set aside. It's the object of the misconduct was to deprive him of the opportunity of obtaining that remedy. And now to say, well, that's a distraction, would be simply to bow to the misconduct.
Sorry.
Well, it was taken into account by the Court of Appeal, wasn't it?
In 1999, Lord.
No, yes, in deciding whether or not to order a retrial.
Oh, absolutely. When I said the Court of Appeal, I meant I was positing my client's entitlement to a stay at trial, 1998,
Yeah.
and on the first appeal in 1999. That's what I meant. Oh, yes.
But the Court of Appeal did have regard to that.
Well, they did, but we submit they didn't. They had regard to it, but first of all, they did not clearly say, as we submit they should have done, reach a conclusion about whether Mr. Maxwell was indeed entitled to a stay at trial and on first appeal. They flirted with it and went round, as we'll see in a minute, but they didn't actually say, and it requires a finding to that effect before one then goes on to the next stage. Plainly, the only possible answer is, in light of what should have been uncovered to the Court of Trial and should have been uncovered to the Court of Appeal, a stay overwhelmingly would have been granted. So, my Lord, I hope my Lord sees that this isn't an unnecessary complexity or distraction. It's of the essence of justice for this appellant.
Can I just ask, I mean, in some cases where someone may be fairly obviously guilty, is convicted, he or she has a very legitimate grievance because they know that everyone's entitled to a fair trial, and they know that, as in the West Yorkshire police cases, actually they've been convicted on forged evidence or possibly by a complete dummy witness being put up to tell lies. But that's not your client's case, is it? He presumably, I haven't got perhaps the full background as to how this came to light, and you can help me, but he presumably was unaware that, of the background to Mr. Chapman's evidence, and if one accepts that one were to accept that there's a strong prima facie case of him being guilty, he must have thought all along it's a fair cop.
Well, my Lord, that is rather assuming that he knows he's guilty.
Well, I would say, let us assume that if he's guilty, that is the position, isn't it? I mean, he can't have had a grievance, am I right, arising from Mr. Chapman's relations with the police, because otherwise he certainly would have applied for a stay on that basis.
Well, my Lord, he didn't have the material with which to apply for a stay. And may I just tell my Lord?
He didn't. I don't know whether he cross-examined. He presumably didn't know anything about it until much later.
No, my Lord, the defence had, and I can take my Lord to it now, the defence case was spot on at trial. In fact, one can't put it more accurately than did the trial judge at the page 452 in Core Bundle 3.
Five.
452. Bottom of page 3 of the summing up. At G. In particular, the defence also say that you cannot rely upon Chapman because he too, they say, is as bent as a £14 note, even though they use that expression about a different piece of evidence. They say that he's untruthful because he is a man of bad character who's committed a large number of offences himself, that he has a motive of self-service because he's done a deal with the police and the prosecuting authorities, and he's got to go through with it. And he believes even now that there is still more to be got out of it by convincing the parole authorities that he's worth a slightly earlier release than the one for which he's currently scheduled. That is one argument they make. And my Lord, it is recorded also in the summing up, may I just find the reference, that the defence sought to establish that Chapman had received privileged treatment, and really pages, can I just give you, my Lord, the references, pages 19, this is internal pages 19 as we go on now, 23, 42 to, if we look at page 19. Forgive me, I'll just get my... Yes. Pages 19A to B. I must give you a warning in relation to Chapman. I've already said something about him. He's an important cog in the prosecution's wheel. It's alleged he has something much to gain. He says not. You must consider very carefully his evidence, whether he has any motive for untruthfully saying what he's saying in this case. It's not alleged he has any grudge against the accused. It's said, well, all supergrassers are strange people, they have motives of their own. So we see how this was flailing around rather ineffectively at trial because there were suspicions, but the defence simply didn't know. At page 23, at D, just above D. Now, he knows what date he's due to be released and that will happen whether or not he gives evidence. He's got his date in 2000. That can't be delayed. He says he has nothing to gain by giving false evidence. And 42 to 44. At F, the what's in it for him line was pursued. I'll remind you again of it briefly. He says there's nothing. I'm putting myself at risk for the rest of my life. And he basically repeatedly taunts the defence, saying, there's nothing in it, you've got nothing on me, I've got nothing to gain. And at 50, the poverty of the defence's line...
50?
Yes, 50. Yeah. He was then taken through the privilege he's enjoyed as a supergrass, what the wing was like. Well, there's no suggestion that he was accorded privileges that were any greater than those accorded to other supergrasses. So the defence explored it and got absolutely nowhere. And the reason for that was the perjury of Chapman and the perjury, which we point to in our case, of Dunham and Daniels, who swore blind that he was being treated entirely properly, that he was quarantined from the investigative officers, and that he received no privileges, and they were unaware of any social visits, even though he was asked. So, my Lord, the defence were absolutely on the right line, but they were frustrated by perjury. Now, then we move to the Court of Appeal, where... information was published in the press, wildly inaccurate, may I say, to the effect that Chapman had been promised or was given £100,000. But more generally, the invitation to the Court of Appeal was to investigate the relationship between Chapman and the police because of these suspicions. And the Court of Appeal, doing its duty, adjourned the hearing of the appeal from April 1999 for about 6 months, so that this could be investigated. And we see, and this is one thing I will take my Lord to, if I may, please, we see the internal machinations of the Crown Prosecution Service, the senior officers, what are we going to say to the Court of Appeal, preparing these secret letters which are handed up to the court, and then we see actually what is said to the Court of Appeal, absolutely lying, by Detective Superintendent Holt misleading the court. So all the time, in answer to my Lord Mance, this demonstrates the defence had their suspicions, which were absolutely right. They've been completely vindicated, and they were denied by a conspiracy to pervert the course of justice. Now, my Lord, may I offer to my Lord, if it's necessary, from the questions being asked, it may well not be necessary, may I offer to take my Lord through the structure of the Court of Appeal judgment, but if my Lords have that well in mind, that's unnecessary.
The recent, not the 99
No, the recent.
The recent one, that's what I mean. The recent judgment. Would my Lord... I'm grateful. Now, my Lord sees the structure of how we seek to approach our argument. I repeat, very largely on paper. At page 4 of our case, where there are 6 stages, many of which can be taken quite shortly. The first is an analysis of the police misconduct, and that is on paper. I would like the indulgence of taking my Lord to 1 or 2 of those examples in slightly more detail. The second proposition, again, will not surprise my Lords and will not need elaboration. It's simply demonstrating that over 700 years, the common law has been very concerned to protect the integrity of the criminal justice system. The third is to set out the probably very familiar current principles for the grant or refusal of a stay. The fourth is considering this issue of the consequences of my client being entitled to a stay at trial and on the first appeal, and then analysing the errors of law that we submit the Court of Appeal made, and then finally separating out what is meant by compelling in Section 78 of the Criminal Justice Act 2003, which standard the Court of Appeal adopted for itself. Now, my Lord, we set the context from the bottom of that page for the more detailed analysis of the misconduct by pointing up how prolonged and pervasive this conspiracy was, and how there would have been no case without this treatment of Chapman, surrounded by and protected by his and the officer's perjury. The fragility of the prosecution case that I'm looking at my paragraph 1.4 is pointed out by those references in the penultimate line, which demonstrate how volatile Chapman was, how he threatened to walk out even during this trial because he wasn't being given exercise from Millgarth Police Station. That's 531 to 537. 649 is the reference to how the Crown justified to itself dropping the Jennings charge, the extremely nasty slashing of the face of a fellow prisoner, which was a quite separate perverting of the course of justice, and that was to keep him happy, as the CCRC have accepted. Chapman had tried to commit suicide in police custody in September 1996, that's plain from paragraph 595, and he sought to blackmail the police and the CPS into granting him immunity in refusing to sign his witness statements in this case. That's from 799. And turning over to our page 7, paragraph 19, since we are considering insults to the integrity of the system and to the rule of law, we point out that the whole context for this privileged treatment of Chapman was a defiance of the rule of law. At all relevant times, he had been remanded in custody pending sentence by a Crown Court judge, and his transfers to police custody are strictly regulated, as they must be. And we list at 111 what those rules are, and every single one of them was broken. There is a strict regime under the Home Office circular for independent custody officers, etc. And, of course, all of that was entirely subverted. Now, my Lord, may I skip many pages and go to the misleading, this is page 11, G at the bottom of the page, the misleading of the Court of Appeal and the perjury of Detective Superintendent Holt. May we start, please, with what is the truth? And it emerges from, in the CCRC reference document, their statement of reasons, which is in volume 2 of the core volumes, beginning at page 32. And go to paragraphs 439 and 440. And this was a missing page. I hope it's been inserted. 145 was only received from the Crown last week. And this is what Detective Superintendent Holt said.
I'm sorry, I've got the page. I'm just, where in your printed case is this?
It's bottom of page 11, my Lord, misleading the Court of Appeal about payments to Chapman and his expectation of substantial reward. And it appears under another heading, Mr. Holt's perjury, as well. So I'm just about to set out how that is established.
Paragraph, sorry?
439.
Does that begin in interview?
Yes, it does.
And
So I'm looking for 439 on this page 11.
No, my Lord. Forgive me. Fourth page.
No, I've got the paragraph. I've got it. I'm just looking for where you refer to it in your printed case.
My Lord,
That is what I'm asking.
over the top of page 12, Detective Superintendent Holt's roll, 439.
Now that you show me it's on page 12, not page 11, I can find it.
I'm very sorry.
Thank you.
It unfortunately goes across a page. 439, and I hope my Lord does have, it was lately supplied, the following page.
I've put it in,
I'm most grateful. This is what Mr. Holt told the CCRC many years later. In interview, December 2004, Superintendent Holt stated that in December 1996, he had been made aware by Mr. Chapman's handlers that Mr. Chapman was to receive a substantial payout for his assistance to Operation U2 on his release from prison. Holt said that after Major Crime Unit officers joined his inquiring team, he'd be asked by several of them to sign informant payments on a basis that they were expenses, not informant payments, prior to Chapman finally being dealt with and released from prison, because there was going to be a more substantial payout when he was released, but clearly because he was still in a prison establishment, that couldn't be progressed. Holt said Chapman's awareness was that he was going to receive some payout at some stage once he'd been released from prison. He thought it fair to say that by the 10th of December 1996, Mr. Chapman anticipated a substantial payment for his assistance to Operation U2. My Lord, that date is not a coincidence, because that is the date of Mr. Chapman's first statement against Mr. Maxwell. And, my Lord, it's not surprising that Mr. Holt should be acknowledging that now, because this was actually common knowledge. Paragraphs going back 2 pages, please, my Lord. Paragraph 432. A number of police officers who performed custody duties during Chapman's production to Millgarth in October-November gave statements to North Yorkshire Police about against waivers of disciplinary action. The officers recalled conversations with Chapman about his expectations for assisting the police. I recall a conversation saying he was expecting a reduced sentence, change of identity, and a payment of several £1,000s. And another refers to his expectation of being paid £20,000. And another officer at the bottom. So this is all just common talk. And paragraph 450 to 451, not too surprisingly in the history, later on and after the trial, the first thing that Chapman is raising, April 98, the quotation from D.C. Holodny, it was obvious Chapman expected some form of reward or payment. So, and another officer confirms that over the page. It was a note. Now, my lord, so that's the truth. But what was presented to the Court of Appeal on a calculated and planned basis was anything but the truth. We see from the reference of paragraphs 93 to 95 how the Court of Appeal had adjourned the hearing of the application for leave to appeal from the 30th of April in order to investigate this very question. See that from paragraphs 93 and 94.
Sorry, 1994 of what?
Of the CCRC Statement of Reasons.
Yes?
And we can then see how the Crown prepared themselves ultimately for resolving this dispute from paragraphs 211 onwards in the same document. I don't need to read all this out. On that page of the Statement of Reasons, it sets out a draft letter.
Sorry, where has it begun?
This is paragraphs 211 and 212 in the
Thank you, here's had it, yep.
CCRC Statement of Reasons. A draft letter, paragraph 212, denying that there have been ever any discussions about monies being paid to him. In any case, is there at 212. That actual letter was not sent, but it informed the spirit of all of the responses by the police to the Court of Appeal. 214 records the adjournment, and a later letter, which we see, we have a copy of it, was then drafted. And over the page, my lord, at 215, the Crown's skeleton argument reflected counsel's understanding. Neither the CPS nor the police in the case were aware of any reward being paid to Chapman for his evidence in this case. Bernberg's, the applicant's solicitors then sent at the bottom half of this page a long list of very apposite questions. My lord sees at A, any agreement of any kind about him giving evidence. C and D, arrangements and funds on his release. And over the page, top of the next page, L, was Chapman promised anything about other charges he might be facing? And the text of the CCRC's reasons then quotes from the letter which was provided to the Court of Appeal. So it may save us from the actual letters themselves, my lord, I give you the reference, are at the very end of Core Volume 3 at 8E.
Sorry?
At 8E, at the end of Core Volume 3, is the text of the letters, but it's not worth going to them. They're very short, and they simply deny any payments. And they're quoted in the page we're looking at here, in the CCRC's text. Now, my lord, the transcript of perjured evidence before the Court of Appeal appears at the end of Core Volume 3, at tab 8F. Does my lord have what has the heading of a shorthand transcript? I'm grateful. And in camera, ex parte prosecution only, prosecution counsel hands up envelopes, one of them written by Chief Superintendent Renison. The court asks if he's here, and counsel next to 7 informs the court that he's totally unaware of the contents of the letters, which is very surprising indeed. And Detective Sergeant Gray is sworn at the bottom of that second page. and he identifies himself at the bottom of the next page as one of Chapman's handlers. And at opposite 27, Lord Justice Otten asks, there is a reference in the letter to a reward of £10,000, which was agreed without discussion with Chapman to be paid after completion of sentence. That's correct. Can you give us an idea of when that agreement was reached? The agreement was reached possibly 3 or 4 months before the end of his sentence, which was, I believe, August 1999. And he'd given his evidence, it's identified, in February 1998. 41, Lord Justice Otten, when he gave his evidence, was he told at all that he was to receive any form of reward? Answer, no, sir, no. Was he aware of any factor which might have affected the content or quality of his evidence? Not to my knowledge, sir, no. Top of the next page, the reward was in connection with this trial. Yes. Now, his evidence comes to an end, and Chief Superintendent Holt takes over. Line 66, he identifies himself as being in overall charge of the inquiry. He says, top of the next page, that he's aware of the contents of the letters. Question next to 78. There's a reference to a reward of £10,000 agreed without discussion with Chapman. I'm aware that this is the case, yes. To be paid after completion of sentence, correct. Can you give us any idea when that agreement was reached? I've no idea at all. As the senior investigating officer, once the matter had been processed to conviction, I had no further involvement with Chapman or his payment as an informant. Before he gave evidence, was he told, or was anything said to him to lead him to believe he would be rewarded? Nothing at all, sir. For giving evidence against these two men, there has been no agreement or no discussions with Mr. Chapman in relation to any reward or any benefit for his involvement in this particular case. Question. If any decision was conducted with Chapman to the effect he might be rewarded, would you expect that to be conveyed to you? I would indeed. I would have expected to have been privy. Was the £10,000 confined to this case? As far as I'm aware, it was confined to the evidence related to the murder case. No discussion had taken place before that time. That is before conviction, from line 91. And, my lord, the court's ruling and reliance upon the court obviously tested as best it could. There's evidence in the absence of the defence. And the court gives a ruling in camera at 100. We've read the letters, we've heard evidence from 2 police officers, one of whom is very senior, satisfied when the informant Chapman came to give evidence, nothing had been done or said to give him any expectation of reward. Particularly was satisfied there's no substance in the assertions in the press about £100,000, satisfied the article was misleading, and any arrangements for reward or change of identity to Chapman were made a long time after the conviction was recorded. Bottom of the page, my lord, the applicant's counsel are invited in, but still in camera, and in effect, at 111, the court repeats that ruling in the presence of the applicant's counsel, and the perjury worked. Under the cloak of a public interest immunity ex parte hearing, which raises all sorts of other issues which we express profound concern about. How on earth this ended up as being explored in camera and to the exclusion of the applicant's counsel entirely escapes us, which is an absolute misuse of that exceptional procedure. There was no ground for confidentiality about this at all. And we invite the court to make a strong, if this is the understanding of the implications of that exceptional procedure, then it needs to be clarified very clearly by my lords.
Is this I agree, on the face of it, it's something one ought to deal with, but is it mentioned in the respondent's case as to why this was ex parte or not?
It's not, my lord, and of course Milan and Friends were not counsel in that appeal, not, no. or in the appeal of last year. Counsel did then appear who had conducted the trial and that appeal. And, my Lord, no explanation was forthcoming.
Did the Court of Appeal explore it?
No, I mean, there were many issues floating around, and we certainly expressed our strong concern in the same terms as we do before my Lord. But under this cloak, perjury at trial was concealed. And the contrast between what Superintendent Holt told the CCRC later and what he said on oath before the Court of Appeal is quite shocking. And it was common knowledge amongst not the investigating officers alone, but amongst the custody officers. It was just the common talk around Chapman. So all these meetings in the course of those 6 months during 1999, every single officer who was party to those discussions, preparing the letters, preparing the position, telling the CPS falsely what the position was, knew that they were preparing to mislead.
I thought that we were on a different point. That was why these officers, when they were questioned in the Court of Appeal, had to be questioned ex parte.
I agree.
That's a separate point entirely.
It is a separate point. I've drifted. Forgive me. But we
As a
don't...
matter of interest, why have your predecessors ever been asked? Because they didn't object when they came back into court.
Well, forgive me, my predecessors... Well, my Lord, it's difficult for them...
well, it's not. I say you were in the Court of Appeal, but at this occasion it was
different counsel.
It was David Fish, QC, and Henry Blackson.
And Henry Blackson.
Who was in the Court of Appeal in this case.
My Lord, first of all, forgive me. No, we haven't asked them, but Mr. Blackson was sitting next to me in this most recent appeal of last year. And I'm quite sure that if he had any light to shed on this, he would have said so, and he was assisting the court about the history. I appreciate this is not entirely satisfactory, but the inference must be that the applicant's counsel were not really told very much about why. I mean, very often prosecution counsel go before a court of trial or the Court of Appeal ex parte to justify there being an ex parte hearing. I'm sure my Lord follows, it becomes quite convoluted. And thus the applicant or defence is not party to the reasons as to why it's being held ex parte, and so that they can't contest it. But, my Lord, the exploration of this issue on this evidence is, in this way, is unforgivable. One can see the court striving to do justice, asking what questions it can. Impossible for Lord Justice Otten to set all this evidence in the context of this trial and of the series of trials at which Chapman had given evidence. So this was a planned and concerted and successful misleading of the Court of Appeal by perjury, by a team of officers. This is a very, very bad case of state misconduct indeed, and it started in December 1996, and here we are in October, November of 1999, with it being continued. And then it remains hidden, of course, until slowly it comes out during the very lengthy CCRC investigations. And my Lord, the fact that this is aimed at perverting the course of justice is highly relevant to the criteria for the grant of a stay, or, if there's any distinction, to whether a retrial is required by the interests of justice. The fact that there is such a pervasive and long-lasting and shameless, brazen assault and insult to the dignity of our courts is highly relevant, we submit. My Lord sees then how we analyse in considerable detail 3 key dates. I'm looking at page 15 in our case. The number of abuses that surrounded the 10th of December 1996, the taking of Chapman's first witness statement. Then paragraphs 119 and 120, the number of abuses that surrounded the 5-day attempt to basically trap Maxwell into making confessions on tape, which was signally unsuccessful. You see 19 abuses in 5 days. And then the third significant date in this investigation was, of course, the start of 10th of April 1997 of Chapman's substantial statement. So we have 9 further abuses surrounding those. Lord, the second and third examples, before moving quite away from this, with your indulgence, may I take my Lord to these 2 short incidents in detail. I'm looking at page 1818 in our case, and the 2 letters written by Detective Constable Dunham to Chapman, which we submit are very telling. Again, at the end of Core Volume 3, there is a tab B.
Tab B.
B.
These are the 2 letters you mentioned at 122, are they?
Yeah, my lord, yes. I'm sorry, the first is at A. I want to take you to both. A is the first one, dated, unfortunately, in relatively neat writing. I'm not going to take you to all of it, but 1st of December 1996, so this is 10 days before he starts making his witness statements. Written by Detective Constable Dunham. Now then, Carl, how you doing? Hope you've got your head wrapped up nice and tight, observing all the niceties, making the best of a bad hand of cards. It can only get better, surely. It's exactly a week since we last parted company, and I'm still chuckling about the way we parted company. Poor old Jeff Coulter, that's another officer, he slept all the way home, but kept giggling in his sleep as though he'd discovered a new secret late on in his life, which of course he had. Me, on the other hand, I just seemed to see more oncoming headlights than there actually was, and they were such pretty colours, ! My lord, this is a celebration that the officers had with Chapman after the successful conclusion of a different trial, the Ford trial. And plainly, this is the officer referring to him and his colleague smoking cannabis with Chapman and writing about it to him. And the letter ends on 6115. Try and keep your train on the tracks, as any derailment now could be disastrous. We'll write again. Keep smiling, Derek Dunham. My lord, the next letter is 18th of December. How you doing, Carl? Thanks for the letter and really glad you enjoyed the night. Truth to tell, I quite enjoyed it myself. Little bit of this, little bit of that. Variety, they say, is the spice of life. What a spicy night. Let's hope there is a second leg in March. I'm demob happy now and disinclined to dip out on any good times that may be up for grabs. And he then proceeds to advise Chapman, the YEP is the Yorkshire Evening Post, on contacts to make money out of writing a book or writing articles about his criminal career. Right-hand page, 5 lines up, serious about a literary adventure. And top of the next page, successful book publications. And it ends, chin up, Mr. Chapman, they can't lock your mind up. Best wishes, stay loose, Derek. Now, it's not just the misconduct that is shocking, but it is the brazenness of actually writing to this man about the misconduct. These officers, and Mr. Dunham wasn't alone, plainly had no sense of potential accountability for their misconduct. handing over to Chapman, a volatile and manipulative drug addict, this clear material, which he was actually collecting. Chapman would collect these things so as to use them for leverage over the police when he wanted more favours. My Lord, the second and hopefully equally short illustration and final one of the police misconduct arises in our next section of our case, page 19, and it's really the record of what happened during this trial from the relevant custody record. And this is, again, at the end of Volume 3, called Volume 3, tab C and D. C is the full custody record. D is the edited and redacted custody record actually served on the defence at trial to conceal what was really going on.
Sorry, the actual one is C.
Yes, and it begins, I was about to explain, with a document which is different, which summarises. We put it in there because it helpfully summarises some of the contents. But the second, if you turn the page, my Lord, under C, that is the beginning of Chapman's custody record for his stay in Millgarth Police Station during his evidence in this Maxwell trial. And the first point we wish to make is that, quite remarkably, Chapman had access both to the officer in charge of this investigation and to his lawyers during his evidence. This is concealed from what was disclosed to the defence at trial. My Lord, if you please go to page 5372, bottom of the page, visit from Detective Superintendent Holt. Now, this is on the 6th of February, and that was the second day of Chapman's actual evidence. We give the dates for his evidence at the beginning of this section in our case, 5th to the 11th of February. And then, if I could invite my Lord to go over the page to 5375, halfway down, on the 7th, which is a Saturday, weekend break during his evidence, halfway down, allowed to speak to solicitor Mr. Chowdhury. And over the page on the same day, 9:25, solicitor Mr. Clowdley spoke to detainee on phone. And then...
Sorry, we're now on page...
5376, halfway down, 2125.
Yeah.
And then bottom of the opposite page, on the 8th, so this is the Sunday, bottom two entries, detained person solicitor Sean Clowdhury arrived to consultation at detained person's request. Consultation ended at 1 hour and 20 minutes. He is seeing his solicitor during his evidence in the witness box. And 5380 on the 9th, which is the Monday and the third day of his giving evidence, 2140, 9th of February, took over custody of DP, who is currently speaking to solicitor Mr. Curtis on telephone.
Can you just give me the dates you give evidence again?
Yes, 5th and 6th, Thursday, Friday, and then 9th, 10th and 11th of the following week.
Sorry, where was the last one? Took over.
You've set it out at 1.26 of your case.
Yes, it's on page 5380, my Lord, 2140.
Oh, exactly.
Yes. So he's speaking to solicitor 3 times and to the officer in the case. What is also revealed from 5363 is that
5363.
so it's back several pages. Where Chapman, top entry, Chapman asks what arrangements were going to be made for his exercise. And he says he was usually taken away to the countryside. He was informed there was no exercise yard at the station, stated he didn't want to exercise at the police station and intended to return to prison. Detained person spoke to the governor at Lincoln Prison, saying he wasn't going to give evidence. Well, of course, this was typical Chapman blackmail, and it was overcome because, as we see, and this is, my lord, the function of that puzzling first page under tab C. I invite you to go to tab C, please, and just to that first page, because this summarises what would otherwise be rather awkward for us to track through. This is the police's summation of the entries regarding Chapman's exercise after his threatening not to give evidence. And we see on the 3rd and 4th, he's out of the police station for nearly 5 hours and 4 hours. And then on the 5th, which is the first day of his evidence, he's taken out for 3 hours and 20 minutes. On the 6th for 4 hours, 35 minutes. Then he has a very nice weekend, the 7th and the 8th. He's taken out for more than 7 hours from the police station on both dates. And then on his remaining days of evidence, he's taken out for around 3 hours on each day. And exercise is simply code. He's taken out for drinks, he's taken out to enjoy himself, sometimes even left on his own, unsupervised, and that went wrong. Now, my lord, 5381 in this complete custody record, still under C, there is an entry recording at 9:05 on the 10th of February. So this is on the penultimate day of his giving evidence, and it's a Monday morning. Does my lord see 9:05, 2/3 of the way down, a detective rang from court requiring copy of custody record for court, DC Henry. Now, of course,
Sorry. What is the first word there?
a detective rang from court. Yeah. Now, of course, disclosure of this custody record in full would have concealed many things. Forgive me, would have revealed many things, and that was not going to happen. So you have under D, I'm afraid that's my writing edited at the top of the first page, I apologise for that, but it serves to highlight this is what the defence actually got. My lord sees black redactions on various pages, 6469, 670, 6471, etc., and one sees that the served custody record at the last page, 6478, finishes on the 6th of February at 9:10, and the defence never got anything more. So somebody is being very cute and is censoring and frustrating the perfectly legitimate requests of the defence.
I mean, can we compare? Take 6478. What does that compare to in bundle C?
It compares to
5372.
5372. I'm most grateful. And my lord sees if we cut it off at 9:10 with shower, one sees that it conceals the visit from Mr. Holt during his evidence later that day, and of course successfully conceals all the other access to his lawyer from that date onwards. And the redactions conceal various aspects of his privileged treatment.
Sorry, can we just see? 6477 equates to, presumably, 5371.
Yes.
Yeah. So what have we lost?
That equates to 5371.
So we've lost.
We've lost Harrogate area, which is where he's taken for exercise, which makes it plain he's taken on a trip quite a long way from Leeds. And we lose we lose the time when he's returned at 9 o'clock. So it conceals the length of the exercise and the privilege that he gets in going to a very pleasant place.
I see.
Was the matter ordered to be followed up with in relation to the solicitor in any way? Who was seeing this witness during the period he was giving evidence?
Well, first of all, nobody knew about it at trial because of concealment.
I meant now.
Now, nothing has happened.
Has it been reported to the Law Society or not?
No, we don't know.
It hasn't.
6478 looks to be quite a sophisticated job, because you can't do it just by blacking out the letters, because several of them go across lines on 5372.
Yeah. Yes. Well, my lord, somebody has gone through this very carefully to eliminate anything embarrassing.
Well, 6478 is more than an elimination. 6478 is a forgery.
It's a... Yeah. So, my lord, it's very difficult, is it not? And forgive me if my efforts have betrayed that difficulty. It's very difficult concisely to convey quite how pervasive and intricate this dishonesty was, and this degree of misleading the defence and, even more importantly, the court. We've dealt with the court of trial. My lord, I know we'll take on board all our references to the actual perjury of D.C. Daniels and D.C. Dunner, which we set out. And in particular, and we do submit that perhaps one of the most poignant aspects of this misconduct was the long-term frustration of the strong prosecution against Chapman for his knife attack on Mr. Jennings in prison in March 1994 by various devices. We deal with this in our paragraph 1.34, page 20 onwards. This was an attack in front of two prison officers. Chapman is being escorted. He has a concealed weapon. He jumps into Mr. Jennings' cell and slashes him about the face in full view of the prison officers. Jennings is hospitalised. Chapman was asked about this at another trial, the Ford trial, and simply said, well, it wasn't self-defence, it was preemptive self-defence. I feared that he might have a go at me, so I was going to have a go at him. So any concept of this, even on his own account, actually being self-defence went. A simple, very serious case. By various manipulations, it's postponed for 3.5 years, and when Chapman was sentenced, no evidence was offered against him. This is F on page 21, with prosecution counsel telling the judge that Chapman had asserted self-defence in his Ford trial evidence, which, as I've just indicated, was not true, that defence couldn't be rebutted, which plainly is untrue, granted the evidence of the victim and of the prison officers, and that the victim couldn't be found and was no longer interested in the case. Now, he, in fact, Jennings, was in custody within a very short striking distance of the court at that time. He'd never said anything other than that he wanted the case pursued. The officer in charge of that case was never asked anything about it at all. But these detectives, these corrupt detectives in this unit, pretended to counsel that he wasn't available, wasn't interested, and counsel somehow found it in himself to tell the trial judge that it was a dodgy case anyway, which probably wouldn't succeed. And the terrible ending for this, and who can talk about causation? I don't go this far, but that within weeks, Mr. Jennings himself was released, within weeks of this case being dropped, and he committed suicide. Now, this is, in any normal case, my lord, this would be a terrible conspiracy to pervert the course of justice by these officers. But its significance perhaps tends to be dwarfed because it's one episode within such a long-lasting and wider conspiracy to pervert the course of justice. And one of the significances of this episode is as follows, that very often what first comes to mind when there is a conflict between the public interest in prosecuting a case on the merits and the public interest in preserving the integrity of the system of justice, it seems as if it's a concrete case with a concrete victim and a plain and simple frustration, as it is put, as the Crown would put it, as against a sort of abstract concept, a rather vague idea of preserving the integrity of the course of justice. This is plainly not such a case. We have real cases here, a real victim who didn't get justice. We have really serious other offences of heroin being supplied to other prisoners, to the girlfriend of Chapman, via his mother, which got nowhere. We have a male rape alleged against Chapman in prison, which wasn't pursued or investigated properly. We have real cases with real victims.
What was Chapman's sentence overall?
I'm sorry? He received 9 years in prison when, by comparison, my lord, Ford, for instance, who was sentenced for a similar degree and kind of offence, got 25 years.
And he was sentenced 23rd December 97.
Yes.
So that's just a couple of months before he gave evidence in your trial.
My lord, yes. And my lord, may I just please carry that through? Because he was released in August 1999. And this doesn't emerge from the CCRC report, but does emerge from the police reports. And I gladly give my own friends the reference. This is
released August 99?
Yes, he was released 27th of August 1999. My lord, on the 19th of April 2001, he was arrested for bogus official burglaries, possession of an imitation firearm, various other offences, and subsequently sentenced to 10 years imprisonment. So, my lord, this pact for the devil with the devil went wrong at every stage. There are real victims of those offences committed by Chapman to balance against, of course, the real victim surviving victim of the Smales robbery and the deceased and his bereaved. So we have, this is not an abstract concept set against a real case with a real victim and concrete interests of justice.
Yes?
Now, my lord, to make more rapid progress now, leave the misconduct on the basis that I've made a rather inadequate attempt to convey in a relatively short time quite how dreadful this police misconduct was. Its detail is very telling, and I've just picked out some key elements, that is all. Now, my lord, moving on to our very next section, may I do that very quickly, because little of this will come as news to my lords. Page 27 of our case. And the proposition is really one I hope my lords may readily accept. And that is that from the earliest times, the common law has recognised the vulnerability of the justice system to abuse and the profound consequences that result from it, and has acted to protect the system against such abuse. And I'm sure I don't need to take my lords to the text, but it is of some significance that the whole origin of our law of conspiracy it is based around protecting the integrity of the justice system from abuse and from, I'm looking at our paragraph 2.2, from conspirators, false informers and evil procurers of dozens, assizes, inquests and juries. And over the page in 1304, who be conspirators and who be champetors, they that do confeder or bind themselves by oath, covenant or other alliance, that every of them shall aid and bear the other falsely and maliciously to indict, or cause to indict, or falsely to move or maintain pleas. And the statute itself says that all justices should carry the terms of this statute around with them. So a focus upon perverting the course of justice and a sensitivity to it.
What happened to all the officers? Did we have that anywhere?
We know, and it is shocking. No prosecution against any of them, no charges, no discipline, sanctions, or even discipline charges against any of them. And I think I reflect the position correctly, that many of them, by the usual device, have retired.
They retire early.
Yes, and have the benefit of generous taxpayers' pensions.
I mean, I think it said it is in the statement of facts and issues that there was no...
That's right.
No.
Yes, it is.
No,
There
is simply nothing.
No. I inquired of the prosecution counsel at the Court of Appeal and then conveyed that to the court, and the court, and that's the state of play.
Right.
That is the state of play. Now, my lord, the significance of that is that part of this web, part of this picture is that sometimes the rule of law can be vindicated in other ways, and that there's an absolute impunity here. My lord, to continue our little history section, I'm sorry, I hope this is not too much of a diversion. The abolition of the Court of Star Chamber may seem like a real digression, but it is quite significant that in 1640, the statute which did so purported to try to bind future parliaments. That's impossible to do, of course, but it purported to entrench the abolition of the Court of Star Chamber by Section 4, by saying, we set it out in paragraph 2.5, that from henceforth no court, council or place of judicature shall be erected, ordained, constituted or appointed within the realm which shall have use or exercise the same or the like jurisdiction, as hath been used, practised or exercised in the said Court of Star Chamber. My lord, in 1698, in Saville and Roberts, a seminal decision by Chief Justice Holt in the Court of King's Bench, confirming the existence of an action on the case for falsely and maliciously procuring another to be indicted, and that is seen as a very important decision in the development of the tort of malicious prosecution. And then, my lord, we bring together various dicta over the page. In 1796, Mr. Justice Asher, sitting with the Chief Justice of the day, says, "It seems to me that a greater offence can hardly be stated than that of obstructing or perverting the course of justice." And then 3 19th century cases, a criminal case called Tremaine, where the Lord Chief Justice indicated in an early precursor of Connolly and Bennett, if it had appeared that the prosecutor had acted oppressively towards the defendant in preferring the third indictment, we should probably have interfered. And then a civil case, ex parte Games, and then Metropolitan Bank and Pooley. The real drive in the 19th century, my lord, was to preventing abuses in civil litigation. And the new rules of the Supreme Court came in the 1870s and really took over the power to strike out for abuse of process where pleadings are vexatious. And we commend to my lord over the page the sentiments of Sir Jack Jacob in an article he wrote in 1970 in Current Legal Problems. There's no need to say, of course, that he was
Pretty well-known article.
very well known. I'm grateful, and if I may just read a couple of sentences. From our 211, it will, I think, be found that the superior courts of common law have exercised the power which has come to be called inherent jurisdiction from the earliest times. The exercise of such power developed along two paths: punishment for contempt of court and regulating the practice of the court and preventing abuse of process. And then really in his most telling paragraph, he says, for the essential character of a superior court of law necessarily involves that it should be invested with the power to maintain its authority and to prevent its process being obstructed or abused. Such a power is intrinsic in a superior court. It is its very lifeblood, its very essence, its immanent attribute. Jumping to the last sentence, the juridical basis of this jurisdiction is therefore the authority of the judiciary to uphold, to protect, to fulfil the judicial function of administering justice according to law in a regular, orderly and effective manner. And we cite two further passages. And my lord, it is therefore not surprising over the page that in various passages, again, in the House of Lords decision of A against the UK number 2, which rejected the use of the product of torture, that the court refers to these principles. And Lord Bingham, in his paragraph 52, the principles of the common law standing alone, in my opinion, compel the exclusion of third-party torture evidence as unreliable, unfair, offensive to ordinary standards of humanity, decency, and incompatible with the principles which should animate a tribunal seeking to administer justice. And my Lord, Lord Hoffman and my Lord Brown make it plain it's protecting the integrity of the judicial process that was critical there. And similarly, my Lord Brown in the anonymous witness case, Davis, indicated that so fundamental was the principle of the ability to confront prosecution witnesses that any undermining of it would be undermining the integrity of the judicial process.
Well, I'm not quite sure I said that. I said it was for Parliament and that you couldn't just develop the common law to do it.
Yes, my Lord most certainly did.
Parliament has since done it.
Absolutely, with effect which is being considered in the Strasbourg Grand Chamber at the moment.
But I mean, if you needed to persuade us that it was appropriate to set aside your conviction on the basis of this corrupt evidence, I mean, of course. I mean, that point is long since established, conceded, and the rest of it. As a matter of interest, I mean, are there civil consequences? Take Mr. Maxwell, your client's brother. Is he suing anybody? Can he sue in respect of any of this?
Well, first of all, he might be retried as well. The court effectively postponed the possibility that he could be retried, depending on the result of any retrial of my client. The court overtly did that, and the Crown's application was for an order to retry both, on the basis that my client's confessions would be admissible against him under the new legislation. The court rejected that, but said, let's wait and... I'm sorry?
I was just wondering if a case called Hater had come into play. I thought somebody mentioned it somewhere in these arguments.
Well, exactly. My Lord, what Lord Justice Hooper decided was that may follow. So he would have an action in malicious prosecution, granted that unless something else happens and he's retried and convicted, he could have an action in malicious prosecution. But, my Lord...
He could... I mean, has anybody ever, on the basis of a conviction, I mean, I don't recall... I mean, take Mullen. Mullen applied for compensation and it went all the way up to the House of Lords. But did he bring a claim in malicious prosecution?
My Lord, he couldn't, because it was accepted that he was guilty, effectively. Or even if he could, he'd get no damages for malicious prosecution.
Because the malicious prosecution, one of the ingredients wouldn't be satisfied, would it?
Well,
don't you have to believe he's innocent?
Well, my lord, you have to be acquitted, and once his conviction was quashed on whatever basis, he at least gets over that hurdle. He's been acquitted.
But you don't you have to show, though, that when the prosecution is brought, it's malicious?
Absolutely.
Yes, that means surely believing that he's innocent.
That's right. Now,
Well, does it mean that?
Yes, it does.
I was going to say.
Yes. I mean, it has to be malice and without reasonable probable cause. And basically all the evidence against Mullen was completely untainted by any abuse or fabrication.
Right, but take Mansell here. I mean, do you say he does or doesn't have a claim in malicious prosecution?
He potentially...
Assuming he's not to be retried.
He potentially could, but whether that's a realistic possibility is another matter. I mean, obviously he'd have to get legal aid. And one would carefully have to assess what damages he could recover, because I've not the slightest doubt that the defendant chief constable would seek to show in the malicious prosecution proceedings that he was actually guilty. Don't forget that they would put the shoe print evidence, various other pieces of evidence against him, and whether he has a prospect of recovering significant damages is quite another matter.
Just a matter of accuracy, you said that there's been a postponement. That's not how I read the Court of Appeal's judgment.
I don't know.
I mean, they've got a one throw. You can't come back asking for a fresh trial several times. And they've had their throw and they've lost.
Well, my lord, paragraph 88...
No, look, that's leading up to paragraph 90 and also paragraph 89, where they say it's not uncommon you have enough evidence to prosecute one and not another.
Yeah.
And then paragraph 90, we do not order a retrial. That's a decision. No retrial.
No, it is a decision, but my lord, 88 that does express what I have in mind. Until the outcome of any trial against Maxwell is known, and until it is known whether Maxwell will be willing to give evidence against
Yes, I've read it, and all that says is that that's the current state when,
that's right.
At the time when we have to decide whether to order a retrial.
Yes.
They can't. The prosecution couldn't come back and ask for a retrial at a later stage.
Well, my lord, forgive me. Maybe I'm reflecting more some of the discussion and submissions that were made than the terms of this judgment.
So you can come back several times.
I think, well, potentially, how far you get is another matter, but paragraph 88 reflects Lord Justice Hooper's thinking that as things stand at the moment, no retrial for Mansell, but the situation could change. And if Maxwell is convicted, that conviction would go in against Mansell. The evidence of Mansell was always he was with Maxwell at all times, so they would tie him in that way. And then there's the possibility that Maxwell would give evidence against him. Some of the correspondence found a possible hope that he might do so. So Lord Justice Hooper was positing a possible future application for Mansell to be retried, even though it was rejected at the moment.
It doesn't seem easy to square with the section where the Court of Appeal allow an appeal against suppression. They may order the appellant to be tried. Still, I mean, you say...
No, Lord, this would be an application under sections 95 to 98 of the 2003 Act.
75.
Yes, forgive me, 75 to 78 of the 2000. So it would be a different kind of application.
Oh, I see.
And transformation in the evidence.
No, I see. So it's not... This application under section 7 has been disposed of, and this would be a completely different one.
My Lord, that's right. So I understand my Lord's puzzlement because Lord Justice Hooper is quite an interventionist judge. There were many, many things discussed, and one saw the way of his thinking more clearly, perhaps, than appears from the terms of the judgment. Now, my Lord, I've finished our section 2, and section 3 really deals with the current principles. And again, it may be possible for us for me to deal with these in quite summary form. We certainly try from 3.2 onwards to set out various pretty uncontroversial propositions.
We got a lot of quotations in the respondent's case as well.
Yes, exactly, yes. And so taking, my lord, to the detail of certainly of Connolly or Humphreys, and it may be even not even Bennett, it may not be necessary. A and B are obvious. C is important, both in Hunter per Lord Diplock and in Latif per Lord Steyn. It is made clear that there can be no set boundaries, preconceived boundaries to this jurisdiction because it can arise in so many and varied ways. D is very important indeed, and in a sense we've only chosen one quotation, but we face this, that the jurisdiction to stay must be exercised carefully and sparingly and only for very compelling reasons. Those are statements which appear in just about every single authority, and we acknowledge the force of that. E, again, takes from Lord Steyn in Latif that prominent factors are, of course, the seriousness of the offence in balance with the seriousness of the state misconduct. The ultimate question at F is summarised, of course, in many places, but Lord Nichols in loosely puts it in the way we cite. And my lord, may I just pause so that my lord reads that. And it is plain, and again we acknowledge this, that the question is a prospective one. And sometimes this gets confused. Sometimes, in examining, looking back at the state misconduct, it is described as an abusive process. And as in general terms, there's nothing wrong with using that phrase. Plainly here, it's appropriate. It's an abusive process. But that's not the central question. The central question is a prospective one, asking whether the proposed trial would itself affront the public conscience or damage the integrity of the criminal justice system. That is the correct import of some of the authorities my learned friend Mr. Perry has cited in his case, and the correct import of Reagan. There are some wrong things about Reagan, but it's absolutely correct that one is asking a question about the future.
I mean, at the end of the day, it really comes down, does it not, to asking, would the public be more shocked knowing about, of course, all the police misconduct that occurred the first conviction, but knowing too about all the admissions of guilt of these terrible offences? Would the public be more shocked by allowing the prosecution now to prosecute on the basis of the admissions, or by not doing that?
Well, my lord, we do not dissent from that being part of the consideration, but in a little while, I'll take my lord to Professor Ashworth's commentary, where he addresses the dangers of putting it purely in terms of looking at public reaction. There are some dangers in encapsulating the test purely in that sense, because it's very difficult to discern what the public conscience is. Just as Professor Ashworth points out, I'll take you to two passages, if I may, in a little bit, points out the danger and the double-edged nature of looking at the seriousness of the alleged offence. That can tell both ways as well, not purely in one way.
But we're deciding then, when we ask whether justice would be brought into disrepute,
yes,
or whether the public conscience is affronted, we're deciding whether it ought to be brought
yes,
into disrepute, or whether the public conscience ought to be.
Exactly. There is a danger of imagining tabloid headlines, which
yes,
will not...
we're looking at through the eyes of the broadsheets rather than the red tops.
Well, unfortunately, even some broadsheets may not be appropriate, but there are difficulties over actually simply formulating that as as the single test.
We have to postulate a man on the Clapham omnibus who doesn't read either. It's very difficult. The law constantly invokes the reasonable man or the reasonable member of the public, but then, as you say, there are dangers in doing so.
No, there are. I mean, it also has to be the reasonable, properly informed member of the public, and where else does the member of the public get his information from?
It's really rather artificial, isn't it? I mean, we're not really thinking about what the man on the Clapham omnibus would think. We ultimately have to decide what, in that context, is reasonable. And in this context, whether it is so outrageous a behaviour on the part of the prosecution that trumps everything else.
Yes. My Lord, there is a core, if I may say so, a core of a very substantial merit in this concept of the public conscience, and that is this, that it is entirely proper for the court to bear in mind the importance of public confidence in the criminal justice system. Now, that is always going to be properly informed and reasonable. But again, that tells both ways. As really Lord Steyne points out in Latif, if the court always grants a stay for relatively trivial misconduct, public confidence will evaporate at guilty persons getting off on a technicality. On the other hand, public confidence is also damaged if the integrity of the system is threatened, as Lord Steyne says in Latif, by the adoption of the thinking the ends justify the means of getting a guilty person convicted. So public confidence in the system, again, tells both ways, and it's important to keep in mind. That's part of preserving the integrity of the criminal justice system.
One matter which has had increasing attention in recent years is actually the impact of miscarriages of justice, acquittals on technicalities, and this certainly isn't a technicality that you're urging, but anyway, acquittals where there is a strong case for saying that someone should have been prosecuted to trial on victims. And I think that has featured in the jurisprudence of the Strasbourg court. But I'm not sure whether we've got in the bundles anything cited to us on that.
Indeed, and may I reinforce that without hesitation. For instance, in one of the Canadian cases, I think it was in Reagan, a prominent politician had been committing sexual offences against young and vulnerable girls, and the court very properly bore in mind that if this prominent person, as it were, got away with it on a technicality, it would have a chilling effect on vulnerable victims from going to the authorities. That's on the one hand, so having, I hope, made that responsible concession, may I just point up the consequences the other way? Because, my Lord, those cases in which there have been concerns about guilty people, as it were, getting off on a technicality, we submit, are outweighed clearly by the damage to public confidence in the system from clear and established miscarriages of justice, where everyone accepts that there was state misconduct, there was fabrication of evidence, there was non-disclosure, there was mispresentation of expert evidence, and the damage done cumulatively to our system from, if I just list them, of course, the Birmingham 6 case, the Guildford 4, the subsequent May inquiry, Lord Justice May, into that case and the Maguire case, the Judith Ward case, they did immense damage to the integrity of our system. So the damage arises in, everything is double-sided, in other words, my Lord. And the court's task is to see where most damage may be caused. And it's easy to state. It's easy to state the damage to public confidence.
One sees the damage in those cases, but how do you apply that in this case? You're saying a retrial would cause equivalent damage, are you arguing that
it's part of our purpose to try and set up some deterrent to against future misconduct, or what?
Right. Well, my Lord, there are two important questions there. The rationale for the grant of a stay for this kind of state misconduct is the integrity principle. And my Lord has set out 3 sets of substantial writings on this, and the integrity principle is to the effect that the system of justice cannot act upon or condone conduct which is in defiance of its basic values.
We're now talking about stays again. How does this fit exactly into your argument?
Well, I'm sorry, I had, this is going to be a third question I have to keep in mind. I'm going to write that down, my Lord, and I'll address it third. And my Lord, I am sorry. I did want to say something in answer to my Lord's question.
Okay,
It's my fault that I've lost my track in answering those.
Sorry, I beg your pardon.
No, it's entirely my fault. I couldn't
It'll
recalibrate.
reoccur over the adjournment.
I couldn't recalibrate. I couldn't recalibrate quickly enough. But my Lord, the one point I do want to remember, and again, this is a point addressed in the academic writings we have, is the role of discipline. And maintaining and public policy. It is no part of a court in this jurisdiction, whether it's granting or refusing a retrial or granting or refusing a stay, to discipline the miscreants. That is perfectly...
Cases make that plain.
Yes.
The court is not fulfilling its disciplinary function.
That's right. But there are many dicta to show that does not prevent the court bearing in mind laudable policy objectives in vindicating and maintaining the rule of law. And that, of course, includes, as Lord Justice Rose in Mullen said, first of all, hopefully deterring future similar misconduct, and secondly, encouraging proper disclosure at trial of material manifesting that misconduct. So, my Lord, there is a difference between deterring and disciplining. It is plain, for instance, Lord Hoffman in A against the UK makes it clear that it's not the purpose of the court, and it's impossible for the court to deter torture in foreign jurisdictions, although, as he indicated, if there is any such consequence, it's a salutary knock-on consequence, but it's not the primary purpose, it's not at the core of the exercise of this jurisdiction. And, my Lord, again, the academics makes it very clear what the problem, the many, many problems there would be over trying to discipline the miscreants by the exercise of this jurisdiction. Basically, they're not going to be deterred. They're not being punished. They're not before the court. It's a more general and salutary, we submit, policy deterrence that the court will have no truck, will not adopt this kind of misconduct and act upon it. Lord Lowry and Ex parte Bennett put it that way. My Lord, that's 3 subjects where I've indicated that the answer lies in some documentation. And may I just indicate where it is before the adjournment? It is Professor Ashworth's article, and with my Lord's leave, may I take you to it? It's at volume 6, tab 59, where he deals with public confidence, he deals with seriousness of the offence, and there is a general discussion of discipline and how useless that is as an objective.
That's where you're going to be taking it. But
yes, my Lord, briefly.
yeah. Thank you very much indeed. We'll resume at 2:00.